Hello, everybody. I want to welcome you to the Matrexit discussion group call this week. I have said before on this wonderful Sunday, the first day of the week, therefore not the seventh, not necessarily the Sabbath. And what we are going to be doing, and I'm really kind of looking forward to this because I haven't seen any other platforms out there that are really giving out valid information when it comes to the judicial system and giving you the tools that you need to be able to conduct yourself in that scenario if you get drug in there or if you have a friend or an acquaintance that is experiencing something to where you can actually give them um, decent help and comprehend what they're doing. Instead, a lot of what we see on social media is a lot of people acting like they know, but they've never even stepped into a case, or they did one time and they think one little thing worked. And so they might have a golden nugget when really they don't. It's kind of a one off situation. And so, what we're going to do is we've got a Jeremy with us this evening, and he's going to be walking us through some of these details and how this is going to help. Welcome aboard here, Jeremy.
Thank you for having me. Um, Appreciate being here. Yeah, it's nice to be able to share my experience and my insight on certain things that I've experienced. Granted, I'm not a lawyer. I'm a pro se litigant. I've been a paralegal for about 17 years. I've had a little bit of experience. I wouldn't say I'm like the best in the world or anything, but I know a few things, and I've been successful. And I realized that it's not easy learning a new trade right off the start when you walk into things, and it's a different perspective because you're empowering yourself and you're standing up for yourself it's another form of doing your own civic duty, but you've got to understand parliamentary procedure. And from what I understand, and I've been dealing with a lot of stuff, writing a lot of things, and I've defended myself in cases. But what I've noticed is you want to have proper etiquette with the court. You want to be able to respond to them, to what they're saying. Don't say what you want to say without responding to what they're saying. And there's a lot of people that do that. I've also known that there's a there's a different strategy that I use. I remember in the very beginning, I'd always want to argue with the judge, and then I realized that the judge is the referee, and he signs my orders. So I really don't want to argue with the judge. That's not really going to help me. What I do know that's been successful is learning how to argue with your facts. Um, I went to study under Flemings. Flemings, he's a guy that is over in California. He's a professor of law. He's been teaching for a while, and he's got these courses, they're online, they're called Fundamentals of Law by Professor Flemings. Anyway, get your hands on some of that stuff and you start reading through the things that he talks about. He says a lot of people want to come in and they want to know the law, and they go to law school to learn the law. But really, when you go to law school, you're going to law school to learn how to use your facts and to use your facts effectively. And because you want to be able to invoke the law. And the idea is to be able to understand how not to make conclusory statements because the court's been trained to not pay attention when you make conclusory statements. Like you could say, this person intentionally did this. Well, that's not necessarily supported. It's a statement, it's a conclusion. And there's a lot of people that struggle with this, even lawyers. The aspect of it is you have to be able to use your facts in a way to be able to invoke the conclusion. So that would be like Jimmy hit Bob with his right hand in Bob's face with enough force to cause injury. Therefore, one can conclude that it was intentional, an intentional assault. And then that right there would make it so the facts were present, and then you could make your conclusion. And I guess a lot of people struggle with that, and that's kind of what the big gap has been. And I think that being pro se in general helps you because you understand your facts because you know them better. But the biggest struggle you're going to find is dealing with your own emotions. That seems to be the biggest deal of it, is dealing with your own emotions because you didn't get your motion granted, or you were told something by somebody and it didn't work. There's just a lot of different things. Just recently, I was in a debate with somebody, and they were telling me it wasn't really a debate; it was just a talk. I guess they didn't understand the difference between collateral attacks and material attacks. And it was interesting because I was trying to give them a scenario where they could understand, and they couldn't understand for the life of them. They just thought an attack was an attack. And the argument was that they wanted to challenge the judge's oath of office. And this is, I mean, I understand, there's people that have this argument, and I appreciate that. But there's collateral attacks and there's material attacks. If you're in a debate or an argument, and then you're like, I'm going to win this debate because I'm going to cancel the meeting, that's really not winning the debate. And usually that's not going to be something that's heard if they really think that you've committed a crime. So they're just going to continue to move forward. People need to understand that they could bring it up over and over and over, but it's still not going to change anything because it's a collateral attack. What's going on is you have a certain amount of time before trial. You have this rule in which you can make objections. And if you don't make those objections before trial, what happens is you waive those objections and you can never bring them up, ever. You're done. If they're not brought up before trial, you've basically waived everything. So if you don't bring those up and you don't write those motions and you don't pertain your facts to support those arguments, you're basically just waiving all your rights. When you go to trial and you lose, or if you try to win, or you try to put that evidence in that you didn't put in, it won't be usable. So you have to literally come into the discovery proceeding when you have a charge come against you, and you have to come and you have to ask for discovery right away. You have to get this discovery. You have to see what this evidence says, all of these pages of everything. Sometimes you'll get a copy of 5 things of the same thing. Sometimes you'll actually get something that's accurate. Sometimes you'll just get a bunch of stuff that doesn't apply to you. It doesn't matter. It just seems that there's like a big illusion sometimes, and some of these guys don't do their work. But I find that if you employ honesty, that is your best weapon, and to use it in the stand in honesty with all of your emotions, your writings, the way you're talking to people, the way you're talking to the judge, the way you talk to the your opponent in the ring. But the aspect of it is to understand your arguments. You have to really do your research. You have to find out, what does this topic really say according to the law? And the reason why I had this guy that I used to listen to every once in a while when I was a kid, he used to tell me that the court doesn't care what your interpretation is. They don't care. I was like, what do you mean they don't care? That's just kind of rude. He was like, no. Let me say it a different way, or a better way. He said, if you go by what the judges say the interpretation of the rules are, then they can go argue with that judge about it. You're not the person making that argument now. They have to look at their boss is making this argument. It's a different perspective. And I saw that and I was like, that really makes a lot of sense, but I didn't really understand the application of it for a long period of time. And the application of it was you really have to issue spot. You have to understand your issues. Sometimes people say they want to bypass college. They want to bypass the education. You're not going to be able to do that, man. You have to really educate yourself. You have to understand what criminal law is. You're going to have to understand what criminal procedure is. If you don't have like access to this information. You could get it online. You don't have to go to law school, but you can literally buy Fleming's stuff online and read it yourself. And here's MP3 player of things. You can listen to the outlines. You can practice it. You can buy the books. It's really, it's an art, and it's been hidden from the people. And it's strategically designed that way, I think. But I don't know how else to say it. It's a big problem, because what we're seeing is there's a lot of people that put out misinformation out there, and the misinformation gives good people that are really trying to help people a bad name. And it also tries to turn the court system into a ruckus. And really, we have really good arguments most of the time if you really sit down and look at your facts, because your facts will most of the time will be saying that they didn't do it right. And if that's the case, then why not use the facts to win your case? Because it's a material attack. I don't know. It made sense to me after I understood it. But the aspect of knowing what you're gonna do and being able to say it, and being able to say it because it's in your head, you didn't have to tell your lawyer it, that's going to save you a lot of money. So you're going to be benefiting from this in a lot of ways. But the aspect of knowing your arguments, knowing how to address the court, knowing how to be respectful in a high intense atmosphere, knowing how to control your emotions. Honestly, talking to other attorneys, granted, you're not going to have an attorney that represents you or something like that, but you might run into a complex argument. You might want to ask them a question just randomly. You don't have to have them write a document or anything like that. But the aspect of asking and trying to see what they have seen and just getting a little bit of perspective, that's really important. I would say some of the most effective tools I've used to be able to learn how the system works is to go to court proceedings and just sitting down and watching how things interacted and how they watched, or how things worked. How whenever I saw a good argument, I noticed that. Whenever I saw a word that I never heard, I'd write that down. Then I'd go look at that up. I also seen another kind of different thing where there were certain people that would be really, really, really rude to the court, and then there was people that were really, really eloquent and articulate in what they said, and the judge would take note of it and rule in their favor. But the other guy that would argue with them, that didn't really work out. It was kind of interesting. I noticed that you can do a lot of things in the court system. You can file a lot of things. You can do a lot of things. But the most effective ways that I've seen to win is to look at your strategies that you have for objections. Your objections are like, motion to dismiss for failure to state an offense. That means that they didn't invoke the elements of the statute because the facts didn't support the statute. You have speedy trial because they didn't, prosecute you within a certain amount of time. And, they have times where they're waiving things because of tolling and all that. But you do have constitutional rights because they had too long to prepare. All this other stuff. You should really read the cases, though, and see how these things work. And then you have multiplicity, where they're charging you for the same charge multiple times for the same offense and the same event, everything. And they usually do that because they have a weak charge, but so they just plaster it to make it look like it's just really strong. But really, when you start going into the fact pattern, you see that it's not really strong. Sometimes it is. I'm not going to say all the time, but most of the ones I've seen have been very weak. Duplicity. These are all motions to dismiss, by the way. And duplicitous means you have a charge that has multiple counts inside the charge. Like you have assault, and then you have theft in the same count. And you're like, well, which one is this? And they're like, it's both. And you're like, No, come on now. That's ridiculous. You didn't even invoke the charge. So they've got like a duplicity, failure to state a claim argument. It's like a combination of the two. You've got vindictive prosecution. You can always show that. This is an interesting one because when you do this, you activate them having to respond to you. They have to. They have to give you a good answer too. It's interesting. Then you have motions to dismiss for fabricating evidence. That's a good one, but it's going to be a battle. It's usually uphill. You better have some clear and convincing evidence. You better make your arguments strong as can be. Motion to dismiss on lack of evidence. Those arguments are pretty strong. You just have to emphasize the facts. And then you also want to move to admit it in the evidence that there is no evidence to support this. It's another key that I overlooked. Then you also have things like motion to dismiss for institution of prosecution. It's like, man, what the heck happened here? How did this start? And then you can find out what they did wrong in the very beginning and find out how they did the case. And if they instituted the prosecution wrong, you can actually move to dismiss based on that. You have motion to dismiss for lack of particularity. You see the indictment. The indictment charges are quoting the statute only. You're looking at the statute and you're like, wow, man, where are the facts at in this? And then they don't have any. It's just like a bunch of conclusory statements galore. And because nobody wanted to work that day, I guess, and they just, went in and served the charge. And then the person goes in and they don't attack the lack of facts and then they get convicted. Or you can because you didn't get notice because the facts aren't in there, you can basically move to dismiss based on lack of particularity. You also have lack of specificity. Those are different type of angles, but yes, they pretty much lead to the same conclusion that they didn't have facts to support the charges, so they're insufficient allegations. That's the language for that kind of is what I've understood. And, I'm not giving you legal advice. I'm just giving you experience advice. This is a little bit different. You also have to understand that you have different angles. Like you have this glorified motion that is probably one of the best motions you should probably ever learn in the history of the country. And that's called the Brady motion. And you want to make sure that you understand that if they fabricated evidence and you can prove it, then they broke the law. And if they broke the law, that means that they didn't have immunity at all. Okay, so if that's the case, this is a very important key. You can move to discharge the charges along with your motion, and you can move for relief of claim of damages, and you can move for sanctions at the same time, all with the same motion. They have to respond to all of them. And it's a nice place to be if you got a really good argument. But, that's a royal straight flush. And that's a fun one to do if you know how to do it. We did it in the Bundy case in Nevada, and it was a really weird situation, but we were successful helping Ryan Bundy, and it worked. And when I saw it, we were just playing around, and we were wondering, are they going to really sanction the attorneys? And we put it in there just because we were right, not because we thought they were going to do it. We just knew it was right, and we put it in, and they sanctioned them. It was like, well, boy, is that fancy. And then I started to realize more or less, if you know how to use these rules, you know how to use your facts, you're going to have a lot of fun in this court system. And but it's going to take a little while to be able to do that. I would have to say Gilbert's law summaries. I was working with a friend that was going to law school for a little while. And while he was going to law school, he called me up and he was like, man, you got to get this book, man. I don't even know what you're doing. I was like, what are you talking about? He was like, you got to get the Gilbert's law summaries. I was like, why? He was like, it's going to teach you how to analyze, it's going to teach you how to do legal writing. You really need to do this because you're going to teach you how to research and all that. And, I used to hang out with a lot of different people, and I had I was an insurance salesman for a while. So because I was an insurance salesman, I knew how to talk to people and kind of relate. Well, when I got into the court system, it was weird because I already had this skill, but I didn't know how to use the motions correctly. And then I had people that were telling me all these pipe dream motions and silver bullets that were just going to get me in more trouble because all I was doing was wasting my time and waiving my objections. Um, but the reality of it was, is when I realized that, and I started using the motions, and I started doing things correctly, and then I started speaking correctly, I started noticing that, wow, this is actually a lot more fun than they try to tell you. And it seems like people are just scared of the court system and they're scared to talk about it. So because of that, a lot of people just don't get it. But then again, then there's also a greedy factor. People know how to do this stuff and they don't want to share the information because they'd rather make money off of it. And I understand that too. But then what we see on these platforms is we see all these people that come out. I'm not saying everybody. There's some good guys out there. Okay. But at the same time, I see that there's a lot of people out there that will give you these false hopes. They'll charge you money and then they'll say stuff to you like, the reason why your motion didn't work is because you didn't believe in God. I can't be around people like that. It just bothers me. I can't work with people like that either. And I've seen some of these guys get real popular on the internet, and they'll tell you they're going to put a lien on a judge. First of all, that's going to put you in jail for a long time, 10 years, federal crime. And they're telling people to do this, and then they're giving them money and doing it. That's scary. And then I remember dealing with one of them, trying to deal with one of the people that I was working with, and he told them that he was going to get him out of jail the next day if he gave him $10,000. And it was weird because he did give him the $10,000. And then after he did it, he told them, your motion didn't work and you didn't get out of jail because of your lack of faith in God. I heard this person say this 4 or 5 times, and those people have called me after that they were already in jail. And I don't know. I don't understand why people do that. I can't literally understand the aspect of why would you want to do this trade and do this and then teach somebody wrong and it's going to hurt them really, really bad, worse than they could have ever imagined. And it's like a joke. That bothers me. And then I also see people, they don't want to talk about politics either. But the reason why we're dealing with such a major problem is because people don't want to get involved in politics either. So it's like you've got the court system abusing people, politics abusing people, and then those are the places where a lot of the common people don't want to get involved. And I mean, that's not a coincidence. I remember being a delegate and trying to pass laws before, kind of like as a lobbyist, kind of just for the people, just out of good nature, because I understood the parliamentary procedures of the court, and I understood that if I employed those in the political atmosphere as well, that they were going to work, because you're using motions, you're making oral motions. It's pretty much a motion, but it's you're making it with words instead of writing it, and you're still making oral motions in the court too, so it's not that far away from each other. So when you come into these groups like the Judiciary Committee or whatever, and you got these problems that these people want to talk about, they're like, man, they've got these illegal this and they got this illegal that. Well, they're not going to hear about that when you're talking to them in the court system. They're going to hear about it in the political room. And I remember one time, just to mess with everybody. Now, granted, I can't believe I'm going to say this, but the reality of it was we were messing around with a friend. We're in this political group. It's a Judiciary Committee. And I decided that I wanted to change the judiciary. And my friend and me had, thought about this. And I said, all you got to do is second me, all right? And we'll get this sucker on the floor. And he's like, all right, man. So I wrote the plank up, and the plank said that the Republican Party of Alaska supports that if you are a Freemason and a judge at the same time, then it is a jailable offense of 20 years. Then I made this argument and I put it on the floor. My buddy seconded it. It was on the floor. I'm like, oh man, this is awesome. So now we're going to be able to debate about this, but we got to wait till it comes up. They found out about that, and there was a lot of people that showed up all of a sudden. And it was weird because they just showed up all of a sudden, like right after they heard that. And then my buddy was like, now watch everybody that raises their hand. And I was like, this is after we made this argument. We both got up. He made his argument, and I made my argument. But essentially, it was two different versions and perspectives of they have a higher loyalty to their brotherhood than they do to the people they serve. Therefore, it's a conflict of interest. Therefore, they shouldn't be able to do it whatsoever at all. And based on the fact that it will mess with their vote. It was basically the logic. And all the people that showed up voted against it. And some of the people that testified that were voting against it were like, I am a judge and I am a Freemason. It was kind of interesting how many people said that. And it was just exposed itself on the floor. And I was like, man, how come people don't do this? This is actually kind of entertaining because you can see a lot of things if you get involved here. But I don't know. I guess because they just never think about it. But no, getting involved in the court system is very, very, very fun if you know what you're doing. It's really hard to do at first, to make the jump, to be able to go and say, I need to listen more than I need to talk. I need to write things down a lot. Sometimes I've noticed that if you're trying to remember something, you have to understand that you're going to be able to remember some things like probably at 20% by hearing it. And then the big difference between that is if it applies to you, you might be able to remember it a little bit more. But when you write it down, you remember it around 80%. And if you could relate it to something, you'll lock it into your long-term memory. So using your mind to be able to store this information in a high capacity, so it's there whenever you have it at random, it's a very, very, very effective thing. It's going to help you with all your debates. It's going to help you with all the people you talk to. But I'm realizing you got to be more patient with people when you're starting to teach all this stuff, because sometimes you come off so like they think you're arrogant or something because you've got all this experience, and you're not arrogant, you're just cocky, or you're confident. You're not even being cocky, you're being confident in your experience. And I guess that can be confused, and people do fall into that criteria. But the aspect of it is learn. What was it? Albert Einstein said it. He said, learn the rules of the game and play them better than everyone else. It's not different. It's the same thing. But it's just a different avenue, a different sport. And once you kind of understand how to raise your points, make your arguments, make your closing arguments, make your counter arguments before they even come in and make an argument, you make it so they feel really stupid to be able to argue against you. And these are some powerful weapons. I'm just telling you from experience that I've seen work and I've used. But you want to make sure that when you're doing this, you're not making them feel stupid. You're also kind of walking them through it, so there's not much thinking going on. They're just following you. If you get them into a situation where they have to think at all, yeah, that's not going to help you. From what I learned from Fleming's is when you're writing out your facts, there's a certain thing that you have to understand, and it's the maxim of law. And the maxim of law is, out of the facts arises the issue. If there is no facts, there is no issue. So you have to use your facts to be able to write. And when you've got your motion, you could move to do whatever. It doesn't matter what you're doing. You're just asking for a request to the court. If your fact pattern leads to this and there is no law, you can still IAC it. And an IAC is, here's the issue, here's an analysis of the facts, and here's the conclusion. IAC is a real easy way of making the court understanding what you're wanting without going into like schizophrenia on paper, I guess is what it is. Really what you've got to do is you got to stay on topic. If you can practice writing essays to where you can have one topic that you're talking about, and then you can close on that topic and then turn it into a request, and you find the rule that you're trying to work it on, and you've got your case law. And remember what I was telling you, if you look at your interpretation of the higher court of that rule, then you start making your analysis with your facts based on that rule, and then you come to that conclusion. It leaves no, it makes them want to grant it because you've done all the work for them. They don't have to think about it. And that's a very successful strategy. I've used it over and over and over and over. And but beforehand, I remember, I guess I thought I was like the second coming of Moses or something, and just put all this law on a piece of paper where I was citing case laws, and just turned that in, and I was like, yeah, really felt like I was getting somewhere. And they were just like, well, how does this law apply to the case? And it's like, man, they can just ask real simple questions to make you feel real dumb. And it made me kind of feel that way whenever it was kind of asked. But when you put it down with your facts to where they can't even think, and they come to the conclusions that you're trying to drive them to, as long as you cite your facts correctly and you invoke the rule based on what you're trying to say, you can move for your rules of evidence. It doesn't matter what the rule is. You just have to understand the concept of, here's the story. And the story is like David is going to be at the football game tonight if Jenny goes. And then you see David at the football. I saw David last night at the football game. Well, we know Jenny was there. That's the mentality of what you have to do when you're reading these statutes, and you have to reciprocate the fact and then invoke it with the facts. Once you have that, you'll be able to understand how you're using the court rules. You'll be able to make it so that they have to come to the appropriate conclusion, and then you're going to get your answers the way you want them to be. But they're not always going to grant them. Sometimes you'll find that a judge will rule against you just to find out where you're at. He'll go, oh, rule against you. And when that happens, you can challenge it with a reconsideration, and they might even still deny it. But there's another trick that you can do on top of that. You can make your rules for objections, and you can say, this is the stuff that you overlooked. So you put it all out right there, and it puts it right on the table. Then they'll have to address it again. But the thing is you do have tools. You do have ways of winning. But it's a science. There's a method to the madness, and it's going to take some discipline.
Jeremy, if I can add to that, I've got information on the IRAC method. I'll post that in the group for people. But I was talking to a young lady a few months ago that was in paralegal schooling down here, I think Florida State, something like that. And so I started talking to her about some of these things, and I brought up like the IRAC or the IAC method. Mm-hmm. And she said, I don't know what you're talking about. We haven't learned that yet. And I'm thinking, gosh, that is like so basic. I mean, when are they going to teach that to them? Like year 3 or something? I just had to laugh, because that's one of the things I think that's going to be important to show people here, as well as writing affidavits, how to correctly write out an affidavit, how to correctly do motions and what kind of motions you want to do, and be able to arm people with some of these just very basic tools that even some of the skilled people in that field don't even have a good grasp on.
Yeah, Brady's one of them for sure. You've got all kinds of tools. Your affidavit is usually, what's interesting about the affidavit is if you have a strong enough affidavit, most of the time you can just motion to admit this affidavit in as evidence. And if the affidavit's strong enough, you can throw the whole case out. And I've seen that happen many times.
Let me bring up something about affidavits as well. since we're on that, and it, coming from you, maybe it'll carry more weight when I tell this to people. I think they just kind of blow me off. But people think that they can write an affidavit to pretty much whoever they want. And, well, number one, most of the time their affidavit isn't even laid out correctly. It's not even technically even an affidavit. But then they've got this belief, because they read it in David D. Robinson's book, that an unrebutted affidavit stands as truth. And it's like, guess what? Not everybody is required to answer your affidavits.
Okay, if you're in a court of law, and I was to file a motion,
right,
I put an affidavit in there, and then I said, and this was in support of my motion, and I was moving the court based on that affidavit. Yeah, that's an effective tool. If I'm serving the guy at Burger King an affidavit, I don't see that one. Just doesn't make sense. What's he gonna do? I mean, this is like calling double dribble on a mentally challenged person. It's just not fair. It's just like,
right,
why are you doing this? It's not cool. And I don't think that people correctly understand what an affidavit is. I saw another thing that's kind of funny was affidavit of truth. The affidavit is supposed to be sworn facts. What are you talking about?
That's one of my favorite ones.
That's so weird. I just, who created that one? That was awesome.
Yeah. If somebody writes, affidavit of truth, it's not even going to get read, because the second they see that header on it, they're going to know immediately that you don't even know what an affidavit is.
Yeah, and that's just pretty much checkmate. But I mean, sometimes you could write an affidavit and not even touch base at all. You could be talking about, just completely irrelevant stuff and never hit it ever. And that really is another important thing that people need to see. Like what you're saying, is structure.
I had a funny situation happen several years ago. Somebody sent me an audio of their court hearing, and they're like, "Oh, I took over the court. I owned the court. Da da da." And I listened to it, and during that hearing, they didn't address any points that were brought up in discovery. I mean, they didn't even address the charge at all. I mean, they were going off about the yellow fringe flag, the judge's oath, the government's a corporation. That's all the stuff they were going on and on about. And the judge really just ignored them and just set a date for continuance and just kept the ball rolling.
Yep.
And this person sent me this audio, and I'm listening to him like, what's he talking about? He didn't own crap. And so I thought, this would be a good learning experience for people. So I put out, hey, I wasn't going to put it on blast, but if anybody wanted to listen to it, contact me. I'll send it to you. And lo and behold, guess what? He was one of the people that contacted me. Oh, I got to hear that, Brian. Send it. I'm thinking, oh my gosh, dude. I just identified exactly the audio that you sent me.
That's hilarious, man. That's hilarious. I remember one time watching the movie Idiocracy one time, and my friend got really mad. I was like, why are you so mad? He was like, this movie's making fun of me. I was like, wow, okay, that's different. That's people I had never seen before or ever thought of. Thank you. That was awesome.
Yeah, you definitely see some good comedy in this arena. And, I want to bring up what you were talking about early on, and that is that this is part of what bugs me, because, out of a list of things, I wrote a couple pages of topics that should be covered in schooling. I'm talking K through 12 schooling. Yep. And part of it would be a basic comprehension of the judicial system, because everybody pretty much is going to face it at some point. And it's at least going to show basic methods of thinking that people need to be able to wrap their mind around. And I wrote that out, and it's like that, these are some of the things that people need to know about. And I don't recall right now exactly where I was going with that.
Well,
but I think that's the things that we would need to put. Well, I was going to say, you said that it isn't taught, and you think it's somewhat intentional. I would say it's totally intentional, because how much money are they making off of people having absolutely no clue on what's going on in that courtroom? Tons of money.
Well, I mean, it's a very big business, but the thing is you just said it. so well. The aspect of it is they need to have some education. Now, if we go back in history, we see that they used to graduate the sixth grade and be able to write writs. What? Man, a sixth grader writing writs? I couldn't find a sixth grader writing a writ right now if my life depended on it. You know what I'm saying? I mean, I just the concept is just blows my mind, but the reality of that is so awesome. A sixth grader could write. I mean,
Could you imagine raising a child that at 6 years old or even 7 can write a writ? I mean, come on. How are you going to argue?
I mean, come on, he's already started in the game, and it's kind of like, wow, that's amazing. No, I just was really, really impressed. But I remember going into the education part in Texas, and then we asked them to teach contract law, tort law, and constitutional law, and even what was tort law? Okay, tort law, criminal law, and contract law. I was trying to sneak those in to high school because they're really not that hard of a course. You know what I mean? But yeah, they kind of are. You have to apply yourself. But I think a freshman can take these classes and pass them pretty easily. The aspect of understanding where your rights come from, though, I think that's the most important thing. There was a theme that I got from the old timers. They always said that whenever you're reading the Constitution, you have to understand that your rights they're endowed by the Creator, not by government. And I guess because we're getting separated from understanding how to write, maybe that concept is being misunderstood, and they're saying constitutional rights now because you're supposed to have those guaranteed by the Constitution. But I think that if you wanted to go in and you wanted to get this done, you go into your district, say you wanted to go and do your civic duty and you wanted to get it passed in your platform of your party of your state. You go in to the platform for education and you go into the Republican Party is the only one I would even deal with. I mean, I couldn't go in the other one. It just wouldn't work for me. Anyway, I go into the Republican Party. I would sit down in that education class, and then I would move to have the blanks accepted, and then have somebody there to second you. That's usually if you have a small caucus. If you have a bigger caucus where you can't second, you can usually bring the plank up by speaking on it. But usually they have a censor program, pretty bad actually, through some of the bigger states. But what happens is you have a precinct convention, then you have a district convention, then you have a senatorial convention, and then you have a state convention. Now your arguments have to make it through the first, second, and third round before they could ever be even heard at the fourth round. And that kind of sucks. But you just have to make sure your arguments are good. And if you can do that, and you can make it pass in front of everybody through those levels, and then you go to the state. Through trial and error, I found that even if you're right and your argument is awesome, but you're the only person saying it, yeah, it's not really going to help. So what you really want to kind of do is, if you've got an awesome argument and educating the kids, you know what I mean? Let's educate the kids. Let's teach the kids the law, whatever you want to do, make a little button. And you put that sucker in and you get it passed through the convention, you go to state, and then you start making sure everybody gets one of those buttons, and then you make your arguments and it passes on the floor. That will go into the legislature and be passed immediately underneath the resolution. I don't know why people haven't been doing any of this stuff, but yeah, for real, there are ways to fix the country. It's just scary because people are letting it get out of hand. It's total anarchy right now.
Well, to throw a little tidbit out there, you mentioned something about our rights coming from God or coming from the Creator. And I hear a lot of people say that. But if you ask people, okay, your rights come from God, well, where's that at? Show it to me. Nobody can. And to me, I did a video a few weeks ago, and it's very, very simple. Well, what do we have? The best thing that we have that espouse that it comes from God would be the Bible, right? So what do you have in there for laws? You've got the Ten Commandments. And we have to, in law, you have to be able to read things forwards and backwards, inside and out. And so if you go and look at the Ten Commandments, what's it say? Thou shalt not murder. Well, what does that mean? Looking at forwards and backwards, that also means you have the right not to be killed. Yeah. You are not to commit adultery. Well, what does that mean, forwards and backwards? It also means you have the right to not be cheated on. You're not supposed to steal. That means you also have the right not to be stolen from.
Mm-hmm. No, but the right comes from it's said in the Declaration of Independence. It says your rights are endowed by the Creator. That was the foundation of the country. And they said that the rights were self-evident too. So it's that concept, I think, needs to be shared. And I remember I was talking to my brother about it probably about 2 months ago. And I told him, you know what Grandma showed me one time? And he was like, what? And then I explained to him, busted out the Declaration of Independence on him, and then showed him right there, rights are endowed by the Creator. And he was like, wow, I never seen that before. And I was like, yeah. She wanted to make sure I understood that. He was like, that's interesting. Well, that point of view is kind of interesting because you see that if your rights come from God, then they don't come from government. And if your rights come from government, they could be taken away. So the mentality of the founders saying your rights came from God was basically saying their rights don't come from the king. And that's what created the country.
And if you want to claim that your rights come from the government, then all you've done is you've put the government's butt on the seat of the most holy and pushed the Creator out.
Yeah, it's overwhelming. But yeah, there's, like you said, there's common sense laws. They pretty much are laid down in the Ten Commandments, pretty blatantly obvious. I mean, how many times you got to lie to become a liar? Once? I mean, these are pretty easy things. I mean, the Bible just tells you to turn from your wicked ways. And people are like, oh my God, it's so hard. And it's like, yeah, but it's right.
Yeah, well, it really shouldn't be that hard, but I guess maybe for some people it is.
Right.
Well, Jeremy, I appreciate you being here. I don't know how long we've been on. I want to keep these like under an hour, just quick little easy things. But I know it's going to be full of info, and I know you've dropped a huge amount of intelligence on people here this evening that they can go back and listen to maybe a second or a third time to kind of wrap their mind around for people that this is all new to. Because what we're going to be showing is an approach, the approach that you need to take with things, not the approach that, the soft-sit gurus or whatever out there are trying to espouse and charge you for.
Yeah, that's a fact. That's a fact. I mean, well, the main points you just want to point out: it's cost-effective to represent yourself. It's empowering to represent yourself. The flexibility of representing yourself. The personal knowledge that you gain, and then you also get to learn from directly talking to the court and opposing parties, yourself and the court. There's just a lot of benefits of it, and I would have to say that educating yourself is a good thing to do.
Yeah, and for people, I know a lot of people don't have a whole lot of time, but if anybody does have a little time on their hands, go down to your local courthouse, find out when they have different hearings or trials or whatever, and go in and just sit in and listen. Because I know I've sat in court before listening to cases that were like maybe ahead of something that I was going to be addressing, and there'd be an attorney I'd be sitting next to or whatever that I knew, and something would happen during it, and we'd kind of elbow each other and whisper, "Can you believe they just said that? Oh, they should have done this,"
Right? No, you can always check what people did wrong too and see what didn't work. I remember one time I listened to this judge getting mad at this attorney so bad. He was all like, "I'm moving for a continuance." He goes, "Did you file a motion?" He goes, "No." He goes, "You're denied. Your motion's denied." He's like, "You're right. I really need this." And he's like, "I don't care. You're done." So it was just like, oh, wow. No, but really watching that, it was just kind of funny. It was like scolding his children.
All right. Well, I'm hoping that we can do this Sunday evenings at 9 or thereabouts, depending on whatever time is flexible for you, Jeremy. And thank you for being here this evening. And like I said, this is kind of an overview. What I'm hoping, that Jeremy is going to get into more of the nitty gritty, really on, for instance, how you write an affidavit, how it's supposed to be laid out,
Yeah.
And same thing with motions and the plethora of the different kind of motions there are out there, and just some of the basic nuts and bolts on how to maneuver through a basic case. I mean, you're not going to go out and be hopefully not defending yourself on a murder charge or anything like that in the future, but for basic things, this will
Yeah.
become very useful.
Absolutely. Yeah.
All right.
No problem. It's been a pleasure, as usual.
Absolutely. Thanks, Jeremy. And until next Sunday, everybody have a great week. And I will be posting notes down in the description box on YouTube with some of this information that you can access so that you can purchase like the Gilbert book or a law dictionary and start getting a head start on all of this. That way you've got the tools that you're going to need as well. Thanks, guys. Thanks, Jeremy.
All right. God bless.
Bye.